Good afternoon and welcome back. We are back in the hearing on Dominion Energy's approval of its competitive procurement of renewable energy program, which is docket number 2022-238-E. At the time that we adjourned the hearing temporarily for the purpose of our weekly commission business meeting, there were the parties, the witnesses for Dominion were being questioned by the commission, and I think Commissioner Williams, you have more questions.
Just a few more.
You may proceed.
Thank you. Mr. Kojak, with your facilitation of the stakeholder sessions as well as your professional experience, how does Dominion's CPRE program sort of follow industry best management practices?
Sure, it starts with the stakeholder sessions. So typically we have one or two stakeholder sessions. Here we had three, so a bit more back and forth with the stakeholder community. The general takeaway there is that we have to giving an opportunity for feedback and addressing that feedback. That's typical, or has become more typical. I'd say in the earlier days, we didn't really have stakeholder processes. It's become more popular in the last 5 to 10 years, and so this is now becoming more of an industry norm. So we've incorporated a stakeholder process here in this case, and then in terms of the design, nothing really, departs from the norm, in my view, from the evaluation process to, how selections are made and what is expected from bidders. The timeline comports with the typical procurement practice, and the kind of interactions and the overall design of it. When the RFP is issued, when bids are due, when decisions are made, that's pretty much follows the standard for typical procurements, be they renewable or other resources as well. The overall idea is to give the market enough notice that the RFP is coming, and then enough time to respond, and then providing enough time then to evaluate the responses.
And Ms. Best, do you agree that Dominion should continue to evaluate whether the rules and tools that you're using to manage for the CPRE program should be evaluated against lessons learned, supply chain risk, evolving system needs, and emerging technologies?
Yes, ma'am, I absolutely do.
And you've really answered this before, but I'm going to ask it again. Sort of how will you integrate that as time goes by?
So with any procurement, whether it be an all sources RFP, a targeted RFP, or a CPRE RFP, we first evaluate if there is a need, and we determine what type of need is it. Is it a system need for reliability, system dispatch, capacity, et cetera? Or is it an economic opportunity based on the modeling input assumptions? And so when we look at that, we look to say, would that need be best served by a CPRE RFP? And if we felt like that need it could be, and it was sizable enough to warrant the cost, expense, and time, because as what Mr. Kojak has just explained, we've been through this twice now, once with the all source and now with the CPRE. We want to make sure that we're that it warrants the cost of that, and then we would look to initiate with someone like Mr. Kojak and CRA to be the independent evaluator to move forward with that. But again, it really determines what the planning needs are. A lot of factors can impact that. Our ability to interconnect dispatchable, flexible resources might suggest that we could integrate faster, or we might want to look at things differently. But I hope I answered your question.
Yes. And speaking of faster, there was the conversation about the 995 days, and is that an example of where you might need to offer a CPRE earlier than you are planning to, based on the amount of time it will take?
So my understanding, and again, I'm not in the transmission planning group, and I don't initiate the DICES cluster studies. That's done by some very smart people in my company, not myself. But that's a timeline, probably from start to finish. I'm assuming the dates would be the moment that you enter into a DICES study to the moment that that perhaps the intervening witnesses would suggest it would take to construct, interconnect, et cetera. I can't speak to the days, but I don't necessarily think that that's what would accelerate the timeline. I think what would accelerate the timeline would be market conditions that you just described. You know, if we see a reduction in the cost of solar and we have a success in our peaker modernization, if we are successful in getting our joint resource, we have the ability to have online significant capacity, then we have the ability to scale up solar at a higher level, more so than we can accommodate today, just because of our legacy system is a bit aged.
Thank you very much. I appreciate it.
Thank you, Commissioner Williams. Commissioner Belcher.
Thank you, Mr. Chairman. Good afternoon. Thank you both for being here. I want to take a step back, okay? Because this is actually the third CPRE program we've gone through. I think over the course of this, I've hopefully gotten a little bit better understanding. But when we're talking about a CPRE program, what are we talking about?
So that is a solicitation RFP specifically geared towards renewable energy in this case.
Okay, I'm talking about the program that
Right.
we are here. And where I'm coming from is we're using some terms, and I think I'm guilty sometimes of using terms interchangeably where they're not. So we've got a CPRE program, we've got CPRE proposed guidelines, and then we're going to have a solicitation under the CPRE program. Is that kind of a
I could take an attempt at it. So you've probably heard over the course of the other CPREs a framework. You might have heard guidelines.
Well, you've got proposed guidelines attached to your
Yes,
testimony.
I do. So I would look at it from the standpoint of a CPRE program might be a framework that underneath that framework we have a guidelines that shows you the sequencing and timing of what it would take to implement. And then you have the example RFP documents, which is what we put forth to show what would need to be completed as just standard documents that would be a part of each and every procurement. The holistic piece of that would be the CPRE program.
Okay, and that's kind of where I am. We're trying to do the framework here. Is that correct?
Yes.
Okay. So in doing this framework, there's some proposed guidelines that would be followed for any solicitation under a CPRE program. Is that correct? Okay.
Yes.
And so the guidelines, the company's asking for approval of those guidelines.
That's correct.
And I believe that the application said acceptance of those proposed documents, the pro forma documents. Is that correct?
That's correct.
Okay. And I want to get into that a little bit because there's been some concern about some of the terms in there. And you've testified, Ms. Best, this morning that, for instance, the 15% on the uncompensated curtailment, that's a proxy number. That's not set in stone. Was that a fair assessment?
That's correct. Factors may have that number to go up or it may have that number go down.
And when would that be determined?
That would be determined at the time when we feel like there is a need that would be warranted by CPRE. We would then evaluate what that level of threshold would be. Factors that may make it increase might be the level of solar on our system through QF would increase, and that might raise that number, or we might be successful interconnecting our peaker modernization, and that number could go down because now we have resources to load follow the solar on the system. So
is that something that is done with stakeholder engagement, or is that purely something that is done by the utility with regard to that one term?
With regard to that one term, that would be something that we would be able to determine and then work with the independent evaluator, because overall they would have responsibility for the design, execution, and evaluation of the program.
Okay. Is there stakeholder engagement in the design of a solicitation?
There's in the guidelines as we set forth here, there's an RFP notice period In the notice, a lot of these details are set forth. And presumably, when we're making a change like that, we'd include that in the RFP notice. Prior to the RFP issuance, it's open to Q&A on the specific changes that were made.
And based on that Q&A and discussions, potential discussions, there could be changes.
That's correct, yeah.
Okay.
You could make a change that wraps into the final issued RFP.
Okay. Are there, I noticed in the pro forma documents, there are some blanks that are highlighted. A lot of those seem to be price, timing, the names of bidders and contact information. Other than uncompensated curtailment, are there other items in the pro forma documents that could change as well that are not highlighted or left blank?
I think the need section, target, that's a key area that would have to be reflected in the final RFP.
Well, but my question, I reckon I'm kind of going with regard to what's before us with these documents. How do we know what other terms in there are subject to change?
As in the guidelines, there was a list of the key items that are subject to change. Let me just flip to this. So it said the notice.
I'm looking at.
Sorry,
B2.
Yeah, EEB2.
Exhibit A.
Exhibit it. Thank you.
And it says the notice will provide general information regarding the upcoming RFP in terms of energy needs, eligible resources, quantity, timing, resource technical requirements, and then key changes made to the RFP developed during the design of the CPRE program, if any have been made. Those are the key categories of information that would need to be updated each time the solicitation is released.
Okay. I think that's all I have. Thank you all very much. Mr. Chairman, thank you.
Thank you, Commissioner Belson. Commissioner Caston.
Thank you. I'll be very brief. I know you guys have been here a while. Ms. Best, in your rebuttal testimony and during your exchange with Mr. Spear on cross-examination, you mentioned the definition of renewable energy facilities, I think defined in section 5841, 10, 12. Do you recall that?
Yes, sir, I do.
And based on your testimony, is it fair to me to assume or gather that the company has had the opportunity to review that definition? Would that be correct?
Yes, sir.
And thinking about that, would PPA-derived or third-party developed projects maybe transferred to the utility for ownership and or operation, and utility self-build generation, would all of those fit within Dominion's understanding of that definition?
I think Mr. Kojak might be able to answer that question better, but as long as they're all evaluated on a levelized cost of energy as how we're defining the program, I think we would, yes.
Yeah, I would agree with that. I didn't see anything that specified with respect to ownership structure. Is this, just to be clear, is this the definition of renewable generating facilities? I might not have caught that.
All I'm really trying to understand is that's, according to your testimony, the definition of renewable energy facilities, and that definition applying to CPRE. Is that correct?
Yes, sir. So in the definition, and that was in renewable energy facilities, they listed 9 specific resources, and those 9 specific resources were things like solar, biomass, wind. It did not include battery energy storage. So because it did not, we assumed or we implied that that was excluded from a definition of renewable energy facility. So that is why we excluded it for purposes of a CPRE. Now, if there was a situation into which a battery wanted to bid into an all sources RFP, that would be the more appropriate location, because then that would be assigning capacity credits, because that's the value of what a battery would bring.
Okay, I think I understand your logic, what you're saying there. And the company's view is that is the definition of renewable energy facilities, in this case specifically CPRE programs, frameworks, whatever we want to call it.
Yes, sir.
All righty. Thank you, and it's going to break your heart, but I have no more questions.
Thank you, Commissioner Caston. Any further commissioner questions?
Let me make sure I understand, because Commissioner Belser had a point I want to make sure I understood. Now, renewable energy facilities, renewable energy resources, you're talking about the resources that are defined in, I think that was what is it, 120F or? No.
If I may, Commissioner?
Yes.
You're talking, Ms. Best, the definition you're given of renewable energy resource is in 584010F, is that correct?
I'm looking at 584120E, programs for the competitive procurement of energy and capacity from renewable energy facilities as defined by South Carolina Code 5839-120F. Renewables that meet this definition include, and there are 9 resources listed, and none of those resources include storage.
Okay. That I understand what you're saying. And in your testimony where you reference 58-41-1012, let's see, I think this is your rebuttal. Lines 22, 23, you say bids to fulfill this generic CPRE program must meet the definition of renewable energy facilities as defined by South Carolina Code 5841-1012, which does not include standalone battery energy storage systems. But you're saying, what I want to make sure I'm understanding, and I think what I just read, that it's your view, the company's view, that 5841-1012 is the definition for a renewable energy facility, which is what it says. And
Can you reference me the page then, please, on my testimony?
yes,
Is that in my direct or in my rebuttal?
it's in your rebuttal, page 13 of 16. Well, let's see, if you're looking at the side one, it's 14 of, no, actually, one of the rare times they agree.
I see that on line 14 and 15, so yes, sir, it would be,
Line 22 and 23 on page 13 of your rebuttal.
Commissioner, Mr. Cooper.
Chair Powers, and I'm happy to talk with co-counsel over here, but we may be able to help the commission out. I mean, I think this is borderline a little bit of a legal interpretation and just helping to explain how the statute works, and there's a cross-reference. And if you agree with me on that, Mr. Speaker, that may help the commissioners get past this, since we've got 2 non-lawyers answering that. I'd be happy to confer with him and give him my thoughts to make sure he agrees, so there's no surprise. I'm just trying to help the commission get an answer that's effective in an efficient time. Does that sound reasonable, or would that be helpful?
fine with me. I mean,
Okay. Give me
Yes.
one sec just to talk with Mr. Spear, and then I think we could get you an answer that kind of clarifies it.
everybody's ready to go home, aren't they?
We'll take a brief pause here.
So Chairman Powers, I think just to kind of help, all we're trying to do is help guide the discussion from not a testimony, but just a legal. I think the point of this is 58411012 directs you to the 5839-120F. The 120F is where you'd look to see the actual definition and the examples. So they play in concert with one another. I think that you'd look to 120F for a definition of renewable energy resource.
I think we had, he was asking about facilities, she was talking about resource,
And,
there was the confusion.
and I think similar to something that Commissioner Belser was talking about, program, different things. You know, this well could be one of those too, and that, you know, is a facility different than a resource? I mean, it's,
The terms are typically synonymous, so facility, resource from the perspective of a utility that it can be used, and facility from perspective of a developer, it's like their facility. But again, they could be used interchangeably.
okay, well, let me ask it this way one final time, and then, you know, we'll move on. Relative to, at least from the company's perspective, their understanding or interpretation of, I guess, section 58-41-10, which is the definitions. This particular definition, 12, in your testimony, 58-41-10-12, is the definition for renewable energy facility, but it expands it apparently in this to include 58-39-120F, which lists those other resources or facilities. Is that accurate or fair to say?
Yes.
Okay, I'm done.
Chair Powers,
Yes.
may I have when Commissioner Caston has concluded?
I have.
Oh, he's
concluded.
done.
Okay.
I concluded, Mr. Spear, thank you.
I'm gonna take his microphone.
May I clarify for the record that?
Sure.
Thank you. South Carolina Code annotated 5841-10, which is where the definitions derive from, only apply to Chapter 41.
Yeah. Okay. You good?
By their own terms, they only apply to Chapter 41.
All right. Are there any further commissioner questions? Any redirect?
Can you give me 1 second, Chair Powell?
Sure.
Chairman Powers, the company has no redirect. Thank you very much.
Thank you very much. You two may step down.
Thank you.
And Chairman Powers, if I may, and I understand the warning that prior Chair Belser would always give, that it would be subject to our own peril. Well, Witness Kojak has a plane that he has a chance of catching. Is it possible that we could excuse him subject to recall? We can make him available remotely via Teams or phone call either this afternoon or tomorrow, should there be a need for him to be recalled.
That's fine. I'm catching a plane Sunday to Budapest, so yeah, I'm glad for him to get on the plane.
Thank you very much, Chair. And with that, Chairman Powers, that's the company's case, and we rest. Thank you.
Thank you very much. All right, Sasiba?
Sasiba calls Hamilton Davis as its witness.
Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, but nothing but the truth?
I do.
Thank you. It may help if you would place that a little to that side.
Okay. Mr. Davis, please state your name and business address.
Hamilton Davis, 1519 King Street, Charleston, South Carolina, 29405.
By whom you employed and what capacity?
Energy Re, I'm the Vice President of Regulatory Affairs.
Who you're testifying on behalf of today?
The Carolinas Clean Energy Business Association, or CCBA.
Did you prepare, cause be prepared direct testimony consisting of 24 pages?
I did.
Do you have any changes, corrections, additions to your testimony?
I do not.
If I ask you the same questions in your direct testimony today, would your answers be the same?
They would be.
Chair Powers, we'd like to move CCBA witness Davis's direct testimony into the record as if given orally from the stand.
The pre-filed direct testimony of Mr. Davis will be entered into the record as if given orally from the stand.
Thank you. Mr. Davis, have you prepared a summary for the commission?
I have.
Can you give that summary at this time?
Yes, and thank you, Chairman Powers and Commissioners. Appreciate the opportunity to appear before you today. You'll be happy to know my summaries are very brief, so keep this moving. My direct testimony primarily addresses 5 main issues in Dominion's proposed CPRE program that I believe need improvement so as to meet the requirements of Order Number 2023-550, South Carolina Statute, and the best interest of Dominion's customers. First, I describe in detail how Dominion's uneven handling of solar curtailment between IPP solar and utility-owned solar results in higher cost for customers and a bias towards selection of utility-owned solar during the evaluation process. Dominion's proposed approach to solar curtailment within CPRE is also inconsistent with its IRP modeling methodology. I provide multiple solutions for addressing these issues, including the use of tolling contracts, which would result in a more fair and balanced treatment of IPP and utility-owned facilities. Second, Dominion proposes to use an interconnection study process that could result in unnecessary cost and delays in project selection while also deterring robust market participation. I provide recommendations for resolving these issues, including the use of a resource solicitation cluster, which has been approved by this commission and FERC as part of Dominion's interconnection study process. Third, I explain how Dominion's proposed CPRE program would result in unequal treatment between IPP and utility-owned solar, which negatively impacts the bidding and evaluation process. I recommend solutions that would better ensure future procurements result in project selection that best meets the needs of utility customers at the lowest cost, including separate bid tracks for utility and IPP-owned facilities. Fourth, Dominion has not articulated a timeline consistent with the company's IRP for executing on a future procurement. I explain why a procurement in 2025 is consistent with the company's current IRP and with Commission Order Number 2023-550. And fifth, I discuss Dominion's proposal to evaluate solar plus storage bids as energy-only resources without regard to the capacity benefits that storage can provide to Dominion's system. Failing to recognize the capacity contributions of solar plus storage resources would be inconsistent with findings in the company's IRP as well as South Carolina statute. Finally, I summarize my recommendations for remedying each of these issues through a commission order and additional engagement with stakeholders. And that concludes my summary of direct testimony.
Thank you. Do you also prepare cause be prepared servable testimony consisting of 14 pages?
I did.
Do you have any changes or corrections to that testimony?
I do not.
If I ask you the same questions in your servable testimony today, would your answers be the same?
They would be.
Chair Powers, we'd like to move CCBA witness Davis's servable testimony into the record as if given orally from the stand.
The pre-filed servable testimony, Mr. Davis, will be entered into the record as if given orally from the stand.
Thank you, Chair Powers. Mr. Davis, have you prepared a summary of your servable?
I have.
Can you present that summary at this time?
My surrebuttal testimony addresses witness Best's and Kojak's description of the proposed competitive procurement of Renewable Energy Program as a, quote, compliance filing meant to be considered only as a, quote, generic CPRE program within this, quote, high-level proceeding. My testimony shows these characterizations are inconsistent with the plain language of this Commission's Order number 2023-550, which anticipates that the Commission will review and approve a program that, that enables Dominion to undertake renewable resource procurements consistent with Dominion's approved IRP. My rebuttal testimony also responds to Witness Best's and Witness Kojak's dismissal of the recommendations I made in my pre-filed direct testimony as supposedly, quote, outside the scope of this proceeding or alternatively falling outside the authority of this Commission. I show that my recommendations are well within this docket's scope and the Commission's authority and should be adopted to ensure that Dominion's CPRE program is both fair and will yield maximum savings for Dominion's ratepayers. I conclude that Witness Best and Kojak have produced no testimony or evidence that would cause me to revise the recommendations contained in my pre-filed direct testimony.
Thank you. Chair Powers, Witness Davis is available for questions.
Mr. Cooper, you have any questions?
Chair Powers, I have lots for Mr. Davis, but none in this proceeding. So no questions, no cross at this time.
Thank you very much. ORS.
No questions.
Commissioners. No commissioner questions? All right.
I have one, Mr. Chair.
Vice Chair Williams.
Good afternoon, Mr. Davis.
Good afternoon. How are you?
I'm doing all right. It seems like both of us are struggling with something. I don't know what it is, but I'm trying to get through it. Maybe someone needs to get you some water.
I had an eye injury a few weeks ago that I'm still dealing with, and so reading this is rather challenging at the moment.
I'm sorry
I should have warned you guys that I was slightly impaired when I came up here, but I feel good. I'm ready to be here.
Or are you confident?
Ready for
to testify?
questions? I am.
Okay,
I'm
all right.
quite.
All right. I understand there's a difference of opinion about the filing here. It's been described as a compliance filing, high-level filing. I think you have a different opinion. You and your client have a different opinion. Could you just unpack that a little bit more to help us distinguish between your position and the utility's position on this filing and what it's supposed to be?
Yeah, I think our interpretation of the prior order that created this docket was that the Commission was looking for a complete program that could be executed on and deployed to the extent that the IRP demonstrated that there was an opportunity in the market to go procure renewable resources. I think what we've identified, there's a lot that came out of the stakeholder process and that has been filed as part of this docket. We expect that, a lot of that has not been challenged. And so what we would expect is, to the extent the Commission agrees with Dominion and CCBA that that part of the program is appropriate in the best interest of customers, that would be approved and that would be used moving forward. To the extent that there need to be changes, that those would be brought to the Commission. The main focus of my testimony on these 5 issues highlights problems that we see with the program that would undermine, we think, the goals of the Commission from a public policy, public interest standpoint, and frustrate the success of a procurement. And because we believe these issues are being resolved in this docket, we think it's appropriate for the Commission to understand those issues and make a decision as to whether or not the program needs to be revised, consistent with my recommendations or y'all's prerogative, so that when this program is used, assuming it's used, it's properly designed and produces the results that you all expect and that participants anticipate.
So is it unfair to say, is it unfair to say that if and when this program is used, pulled off the shelf, if you will, could the concerns that you have today not be addressed then?
I think they could be concerned or could be addressed. I think my concern is that what Dominion has articulated in its testimony is they essentially intend to unilaterally make these changes, maybe if they decide to. And I think we heard from Witness Kojak that at least a number of the concerns I identified related to curtailment, related to when bids are awarded during the interconnection process. I think, the language you used is, we could do that, we might do that, depends on what Dominion wants to do. We think those are questions that are appropriately answered by this commission. To the extent we don't resolve them in this proceeding, yes, they could be resolved moving forward, but I think we're wasting an opportunity. All parties have put a lot of time into this. I think now is when the questions being asked, are these things appropriate, and are these details best resolved here or left open-ended for the utility to determine at some future point?
Thank you, sir. Mr. Chair, that's all the questions that I have.
Thank you, Vice Chair Williams. Commissioner Carolee Williams.
Thank you, Chair Powers. Good to see you, Mr. Davis.
Good to see you as well.
Following up on that line of question, I guess what rolls around in my mind is, with the exception of the element that you're talking about that relates to the IRP, what's the right time for this to be resolved? If this CPRE is not going to be implemented in the short term, as we've heard testimony that it's not the right time from the company's perspective, is there a time in the future that it could be resolved, when there would be more information that would have evolved? What's your response to that?
Yeah, I mean, I don't think I don't think there's an information deficit here in terms of resolving these questions. I think I've laid out pretty clearly and in detail in my testimony the nature of these concerns, and I don't think that they will change based on, new information. I'd say with something like the interconnection process, whether to use DICES or a resource solicitation cluster based on the volume of projects that are anticipated to bid in, maybe that's a decision that you make down the line, and to the extent the utility, or to the extent the utility has better information about the volume of projects intending to bid in. I mean, I think we heard Witness Best say that they have something like 3 gigawatts of solar projects floating around out there. If they ran a procurement for 300 megawatts and 3 gigawatts bid in, that's exactly the situation you would want to use a resource solicitation cluster to deal with. But I do think, the utility has flexibility on that. We're not opposed to DICES versus RSC. What we're recommending is, if DICES is used, there are timing concerns that need to be contemplated, and there needs to be certainty as to when bids will be awarded, so as not to make that process punitively expensive and needlessly expensive for participants. I guess just, you asked about timing to kind of wrap up this answer. That is one of the things that's also contested in my testimony as compared to what Dominion has put in this record.
Right.
I mean, we interpret the IRP to say the timing is now. What we have not seen the company do in this proceeding or prior proceedings is actually, demonstrate to this commission or other parties, this is what's in our IRP, this is how long it would take to go out and procure, to execute on a program. And so this is, based on this IRP, these are the dates, this is the sequencing. Like, that information is just not being provided right now. And so it's a bit of a black box in terms of what we're hearing, but I think we have all, based on the IRPs that have been approved, we have all the information we need to understand when the timing is right. And, it's somewhat frustrating that we still aren't getting any concrete direction on that issue.
And would you parse out or reframe the 995-day conversation for me? Because I think that, to me, that is relevant to what the IRP says. And so how is that 995-day estimate arrived at?
So I detailed that in my testimony from the prior proceeding,
Right.
But I can recount that here. It essentially is looking at the interconnection study process combined with the construction window at the end of that process. So I agree with Witness Best that 9 to 12 months is typical, maybe even shorter than that under some circumstances. I think 6 months actually is what I used in my assumption around the 995. To the extent that you have a project that's already been through interconnection study and is not going to be studied again and is awarded a bid, then yeah, you're not going to have the study component of that 995 days. But I would not expect, generally speaking, that there are a lot of projects out there bidding in that have interconnection agreements and are just waiting for a contract. That typically is not how the sequencing works. And so I would expect for most projects bidding in, they would need to be studied in the context of the procurement, maybe with some exceptions, but generally speaking, that's the expectation.
Would it be fair to say that it's not a case of, could there be some that are in the process and don't, are midway through or somewhere along that continuum for the interconnection process? It's not like they're those that have not applied and then there are those that are ready to go. Are there others in the continuum?
I think those are probably the two categories, right? They're either in the midst of a study process now. Again, I would be surprised if those projects stay in that study process without a contract, which, in this market would be a PERPA contract. I wouldn't expect all those megawatts that were mentioned to go after a PERPA contract. So I expect a lot of those will not make it to interconnection agreement. But maybe they would bid into a procurement and go back through the study process. So there'd definitely be a mixed bag, especially at this point in time, because some of those, if they open a procurement tomorrow, you've got projects being studied that want to bid in, they would presumably stay in the study process that they're currently in. So that could shorten the timeline for those from that 995-day perspective. But generally, I think that 995 days is conservative based on what we've seen around the region. Through Duke's procurements, through prior Santee Cooper procurements, what's going on in Georgia, other places. 3 years is very quick to run a procurement and then have a facility in operation at the end of that process.
Thank you. I appreciate it.
Thank you.
Thank you, Commissioner Williams. Any further questions? You can redirect, Mr. Whit.
No redirect, thank you.
Thank you very much. Is anything else from any party?
Yes, from CCBA Chair Powers, I do believe that we need to clarify the record with respect to one of my client's demonstrative exhibits. And so if I may just run through that quickly.
Yes. And
thank you, Chair Powers. So at one point, CCBA offered into evidence CCBA demonstrative 6. That was for identification purposes. Chair Powers did not elect to admit that record into the evidence, but it needs to be marked on the record for identification purposes and provided to the Commission.
it will be marked as Exhibit 10 or identified as number 10.
Thank you, Chair.
Anything further?
No, thank you, Chair Powers. Thank you, members of the commission.
Well, thank you all. I don't think any of us expected it to last this long, but certainly got a thorough hearing. And I don't know that I'll see any of you or that any of us will see any of you before the holidays. And I always hope you all have a happy holiday. And if you find somebody you can help them. We are adjourned.